Madam Clerk, if I could reserve 5 minutes for rebuttal. Thank you.
Mr. McAdoo, what I'm going to ask you to do is try to pay attention to the lighting system, because it's going to let you know exactly how much time you have or when your time is winding down.
It's Mr. Mosley, but
Mr. Mosley, I'm sorry.
McAdoo's my client.
I apologize. Mr.
That's
Mosley.
quite all right. That's. I apologize to this panel for being late. I had a bit of trouble finding parking, but I believe that you probably have that on a more frequent basis than I do. To begin with, I do want to address and try to cut through a bit of the wheat here and or the chaff here and get to the wheat. To begin with, the states in their brief has argued for the first time that relief under 4011-204 does not afford an opportunity to revisit issues that were brought in the initial, that should have been brought in the initial pleading. I do want to say that relief under 4011-204 is comprehensive. It is quite.
I guess what I'm trying to be clear on what exactly you're referring to as far as the state raising an issue for the first time. They're responding to your issues in your brief. So what issue are you referring to?
Well, Your Honor, the state in their brief argues that the relief that is available under 4011-204 would not allow the surety, the petitioner in this matter, to request relief or the vacation of the order of final forfeiture. That essentially that the trial court would not have had the authority to address the issue of whether or not a final forfeit hearing was given in a 204 petition. And that's not correct.
I'm not sure that that's what the state is saying. You've got some procedural hurdles that I'd like for you to address that are raised in the state's brief. So tell me, what exactly are you appealing?
Your Honor,
which order of the trial court?
The order denying the refund.
Okay. And so that was the final forfeiture? So you're appealing the order denying the refund?
Correct.
Okay.
The final forfeiture order was put down, I believe, in July of 2024. The defendant, or 2023, the defendant was later apprehended. My client, through other counsel, had filed a petition for a refund.
Now, so I think where I understand you, you're saying that you can now challenge the order of final forfeiture in the order denying the refund.
The procedural irregularities, yes. The 4011-204 is a very comprehensive statute. And in the Supreme Court case, the recent Supreme Court case of N. Ray Rader Bonding Company.
No, well, you didn't. I just want to make sure I'm understanding you before you get into details of the Supreme Court cases. You didn't appeal the order of final forfeiture?
No, my clients did not.
Okay. I just want to make sure that's clear. So I think that's part of what I understood the state's brief to be. So you really don't have jurisdiction at this point in the process.
That is not correct, Your Honor.
Okay.
The argument of the surety is that under 4011-204, the authority, the legislative language there, grants the trial court very broad discretion, and to do all that they may seek to do that is just and right. And so the issue of whether or not the procedural due process was given to my client can be raised in a 204 petition.
But the 204 petition was a petition for exoneration.
It was a refund petition. My clients had already paid the bond, and they were asking for the money back.
Okay. So what was that petition called? What did you call that petition?
A petition for refund, I believe, is what the previous counsel had
Okay, let's
called
talk.
it.
So you're appealing the petition for a refund, all right? So the trial court denied your refund.
Correct.
Right? And so what are you saying was improper about that?
Well, the issue that was raised was an issue that essentially, the original issue at this point in time is I believe, moot. I did not draft that, and I did not argue that, and essentially The matter came to me, and reviewing that, I felt that the judge presented with that initial petition was not incorrect.
All right, I just want to make sure I'm following you, because we have to, obviously issue an
Obviously,
opinion.
it's a confusing matter,
Well, it's not confusing. I mean, we're following your brief as you drafted the issues. So I want to make sure we've got it right, because your brief sounded alarming. As if the trial court was
we'll
really
get to
making a grave error here. So you said, should the trial court have set the case for final forfeit hearing prior to entering a judgment of final forfeiture? That has nothing to do with the trial court declining your motion to reimburse.
It does, Your Honor.
Okay.
Because the issue here is if there was a fatal flaw in that initial order for final forfeiture.
Counsel, was that issue raised, though, in your petition, before when you're seeking this refund, did you raise the issue?
In the Rule 59.04.
But in the original petition?
No, it was not raised.
Okay, so it wasn't raised in the initial petition. So the trial court ruled against you without this issue having been raised. The first time it was raised was in the motion to alter or amend, right?
Yes.
Can you raise a new issue in a motion to alter?
Yes, you can.
Okay.
In the case of Brady versus McLeod, the Tennessee Court of Appeals has ruled that a Rule 59.04 can be raised for 3 issues. The first one is when there is a change of the law between the judgment and the judgment becoming final. Within that 30 days, the legislature acts, it changes the law. Second is that when evidence that was unavailable at the time of the judgment, excuse me, was found between that same time period. The third reason, and this is the reason that we cite, is that when there is sui generis, an issue that would raise a concern or cause grave injustice. And our position is
Isn't it
that
just a matter, though, of nobody bothered to show up the first time there was a show cause, and then no one bothered to raise in the petition that there wasn't a hearing? And what's the grave injustice here? I mean, there was an opportunity originally to have a hearing, a show cause. Could have raised it there. Nobody showed up. Not raised in the petition. Where's the
grave injustice, Your Honor, is that while there were multiple motions for extensions of time granted and filed, and there were hearings regarding that, the court's actions in granting or issuing the final forfeiture order was held without a hearing.
Is that order actually contained in the record here, the final extension order?
I believe it is.
Okay.
The order of final forfeiture that
Not the final forfeiture order, the order with the extension. I think there were there 3 extensions?
Your Honor, I'm not sure. I believe that there may have been one that was missing.
Is the last one actually in the record? The last extension order in the record?
Your Honor, I believe that it was, but when I went looking for it last night, I could not find it.
Okay.
And it may be an issue where everybody assumed that order had been entered and that it had simply not. But
is there any dispute that order? Is there any dispute that order had a show cause date on it, that you could have showed up for a hearing and said, "Hey, we've got a problem in terms of this"?
I would not characterize it in that fashion,
Okay.
Your Honor. What I would characterize it as is that the judge granted, as was the common practice in Rutherford County, an extension of time until June 30th. And that is different from a show cause date, because the entire point was no hearing was actually set. If there had been a show cause hearing set on June 30th, and the trial court and the state did not dispute this in the court below, they agreed that there was no hearing.
I'm sorry.
If they had said, we had a hearing on June 30th and your client didn't show, we wouldn't be here. Because that wasn't what happened. What happened was there was no hearing.
But
There
you
was
were
nothing.
given a hearing date. I
There
mean,
was nothing on the docket. There was nothing set on that date. And the state does not dispute the fact, it did not dispute the fact that there was nothing set on that date.
You weren't given a date for final forfeiture, is what you're saying.
No. There was a
And it
date
just
by which
happened
the court.
By happenstance. It just happened out of the blue?
The common practice, according to what Judge Turner stated in the record, was that in Rutherford County, there are no final forfeit hearings. They simply take action at the expiration of 180 days.
The order that you're saying is the extension order, which is the one that's the last extension order. If that's not in the record, Isn't that deeply problematic for your appeal in this case in terms of, and don't we need a record basis to see there's some sort of problem with regard to the extension order that was issued in this case? And how do we make that determination without that order in the record?
Well, the first issue that I would is that at the trial court, and the state has a very good brief with regard to the issue of waiver. In the trial court, this issue was not raised. There was no discussion about whether or not there was a hearing held that my clients didn't
It's
appear.
not raised in the petition, right? I mean, if you don't raise it in the petition, as the state, I'm not going to challenge the defect based upon an absence of a hearing if there's not an absence of a hearing argument raised in the petition, right?
There was in the motion in the Rule 59.04, and the state had an opportunity at that time to raise that issue. So they had the opportunity to raise that issue if it was a valid issue. And, Your Honor, the entire gravamen of the Rule 59.04 motion was that fatal defect. So if the state is now claiming that there was a hearing that my client didn't appear at, and there's nothing in the record to show that, and the motion itself talks about the fact that there was nothing in the docket system to indicate that hearing took place. They don't challenge that. They don't contest that. So if there was no hearing, and compare and contrast that with what happened in the Danny Blankenship case, because in the Danny Blankenship case, there was a hearing. Danny Blankenship just simply didn't show up to that hearing. And in general sessions, if you don't show up to a hearing, a default judgment goes down, and that's fully appropriate. But in this instance, there was no hearing. And the judge acknowledged that. He acknowledged the fact that
Well, what
they
he
don't...
said was there was an opportunity for you to have a hearing, but you didn't show up, or your client didn't show up. He said this case is not unlike Danny Blankenship. I'm sorry, you at least that's my reading of what the trial court's order.
The judge said that essentially my clients had an opportunity to ask for a hearing at any time. And it is not the due process of this country that a defendant in a civil matter has to ask for a hearing before a judgment is taken against them. That's the plaintiff's action. The plaintiff asked for the hearing, and if the state of Tennessee had wanted a default judgment against my client, the state of Tennessee could have filed a motion for a default judgment under the rules of civil procedure, which would have entitled my clients to a hearing and would have given them notice of that.
Isn't there a show cause in the extension? Well, I mean, we don't have the extension order, right, the last one, but isn't there a show cause in the extension order?
There was nothing said on the court's docket for that day.
But in the order itself, does it say, by such and such a date, show cause?
Each of the two prior orders had specific dates. The ones that are in the record had specific dates for your client to show up in court and either present the defendant or present a reason why there shouldn't be final forfeiture.
And I would say that once again, there's nothing in the record that indicates that there was a hearing on that date.
You keep saying a hearing on that date, and that's not what the law requires, at least my understanding. The law only requires that your client have an opportunity to have a hearing, which is what Rader says, which is what Blankenship says, and only an opportunity is what is required. And that's what was my understanding the trial court said your client got, even though we don't have the order.
Well, Your Honor, again, when you look at the Blackwell case, which is the seminal case, the case that really establishes that right to a final forfeit hearing, it talks about the fact that the surety has the right to raise any objections or raise any claims or any defenses at any time up to the date of the final forfeit hearing, which is required by Wallace v. State and the statute 411-139. And the fundamental aspect of this is that if you never set a final forfeit hearing, and if...
Okay, so do you agree with me that the trial court set final, in the two prior orders that we have, that the trial court set hearing dates for your client to appear, and your client didn't appear? You agree with me there?
No, I don't, because essentially while the order shows that there were dates, it was never docketed. Those dates were never actually...
When you say docketed, you mean that there has to be more than what the trial court puts in its order in terms of a hearing date?
They actually have to have the hearing.
Okay.
If you call someone into court, if at the docket call you call someone into court and they don't appear, then it's their problem. It's their fault. They were called into court. Oh yay, come forth. And if you did not, if that was never appeared,
Your client was aware of these extension orders.
yes, my client was aware.
So I'm looking at one from August 26, 22, page 24 of the record, and it says it's therefore ordered that it's granted extended 180 days. So that was when the clock started running, and your client was aware he had 180 days to raise some kind of objection or to have a hearing, right?
Yes, Your Honor.
And that did not happen.
Well, Your Honor, I believe that what occurred in the interim was they filed another motion for an extension.
Okay, and that's the one that's not in the order.
The order is
resulting
not on the
from-
record. The motion is, but the order is not.
Okay.
And we don't contest that there was probably a June 30th date on that order. I think that there was. The question is that June 30th date was never an actual hearing, as opposed to what happened in Danning Blankenship, where there was an actual hearing.
Doesn't a show cause order put the burden upon your client to come forth and show cause why there should not be a final forfeiture granted here? And if a trial court puts down a show cause order, isn't that putting the burden on your client? And, June 30th, by June 30th. Otherwise, it's final forfeiture here. And isn't that putting the burden on your client?
Well, I still have to respectfully suggest that the language of Blackwell controls in this matter. And that is that my client has not only up until that date, but on that date, to come into court at the hearing and explain what happened. And if there's no hearing, then Blackwell is not satisfied.
You submit that there was a hearing on the prior 2 dates?
There was not, and that was because there had been a motion for an extension of time that had been filed prior to then.
All right, thank you, Mr.
Mosley.
Mosley. Mr. Lundy. Help us out, Mr. Lundy.
I'll do, excuse me. I'll do my best, Your Honor. Thank you very much. May it please the court, counsel, my name is Will Lundy, and I represent the state of Tennessee in this appeal. So before I get to some of the procedural arguments, I want to start by saying why I think the appellant's argument simply fails on the merits. And I want to start with the shira fascis. I hope I'm pronouncing that correctly. This is my first case handling any of these. And what the shira fascis says is that it set the final forfeiture hearing for July 15th of 2022. It said this is the day where we're going to have the final forfeiture hearing. And then, of course, as the court is aware, there were these 3 orders subsequent to that extended that date out. But it didn't, those orders don't eliminate the fact that there was a final forfeiture hearing date set. They just extend the date of the final forfeiture hearing out. And as has been pointed out, the appellant simply did not appear on that date. And that date, again, that third order set that date for June 30th of 2023, and the appellant did not appear.
Where in the record is that? If the order's not in there, where in the record is that date coming from?
That date is coming from, if I'm remembering correctly, Your Honor, the date is coming from the trial court's order, okay. One of the orders that denies it. But you're correct. That order does not exist in the record, and that is a major problem for the appellant's argument. If the argument is we didn't have notice of a hearing, that would be dependent upon that third order, because that would have been the order in which that final date would have been made clear. So insofar as that's an argument, then we simply don't have that order, and that the argument is ultimately waived. But what the court did then after June 30th was it waited until July 6th before it actually entered the final forfeiture order. And this went on for, these extensions went out for a long time. This starts in July of 2022 and ends in July of 2023. The appellant had almost a full year to appear and show cause as to why the final forfeiture order shouldn't be entered. And in Blankenship, as this court has pointed out, in Blankenship, what this court has held is that there must be an opportunity for the bonding company to be heard before final forfeiture is entered. And in Blankenship, I'm not really sure how to understand the appellant's argument on Blankenship. The way I read Blankenship is the sheriff has set a date for the final forfeiture hearing, and that's exactly what happened here. I don't see any distinction between those cases, or between this case and that one. And I believe that the trial court correctly denied the Rule 5904 motion because Blankenship controls. And in fact, it seems to me that if you take the appellant's argument to its conclusion, that ultimately what would happen is we would have a situation where bonding companies are essentially immune from default judgment. And so in that case, if a bonding company wanted simply to avoid paying any sort of a forfeiture, all it would have to do is not show up in court. I think that creates a perverse incentive to bonding companies not to pay their forfeiture orders. And I would ask this court not to take up the appellant's invitation to create such a rule. That being said, let's talk about some of the procedural issues in this case. As the court pointed out, the appellant did not appeal from the final forfeiture order. And I'm going to dispute, I want to be very careful with how I talk about Section 40-11-204. What I don't believe that statute does is I don't believe that statute gives the court the authority to reverse its judgment in the final forfeiture order. And I believe there's a distinction between that and granting exoneration, which is what it does. So if, for example, let's say that this issue was actually raised during during this petition for exoneration, that's how I phrased it in the brief, is petition for exoneration. And this issue about due process and all of this was never raised in that hearing. And in fact, we don't actually have the transcript from that hearing, and because we don't have the transcript from that hearing, insofar as this is an appeal from that order, the record on appeal is inadequate, and I would argue that it's waived. But setting that aside, with regard to what the court can do under 40-11-204, if this argument had been raised and the court felt that it was significant enough that it wanted to grant a refund, I don't think it would be an abuse of discretion for the court to do that. As counsel pointed out, it grants broad discretion, but it does not grant the court the ability to go back and vacate its order as being void or somehow invalid. It doesn't do that. And that's what the appellant is asking here, and I hope that I'm being clear on that point. So
General, if I'm following you correctly, you could come into court here and say, I want a refund, I didn't have a hearing, and the trial judge, because of the broad discretion, could say, you know what, I think you should get a refund because you didn't have a hearing, and we've caught the guy now, and he's in jail, and you were helpful, so I can give you a refund. But the judgment itself would still stand.
The judgment itself would still be valid. That's correct. I don't think you can come in and challenge that, because ultimately that's a collateral attack against the judgment. And as this court is aware, collateral attacks against a judgment, I argued this in my brief, they're only available to argue that a judgment is void, and in civil cases, as I understand the case law, and Judge Usman, since you deal with civil cases far more than I do, you would be in a better position to know this, but as far as I understand it, the only way to succeed on a collateral attack and on a judgment in civil court is if there was no jurisdiction, because that's the only thing that makes a judgment actually void. And I do want to talk about Rule 5904, and I've cited several cases in my brief that address the fact that no, under Rule 5904, new issues are not available to be raised. That's not something that can be done under Rule 5904. So insofar as we're here on an appeal from that order, the trial judge didn't abuse its discretion when it denied the petitioner's motion because the petitioner wasn't allowed to raise any new issues. That being said, there is one other way that I think we might possibly get here, and the trial court talked about it in its order, and I apologize for not having it in the brief. I just sort of I realized it as I was preparing for argument, and that is the trial judge talked about Rule 60.02 as being a potential avenue for reviewing the original forfeiture order, which, again, as I understand appellant right now, he's not actually challenging. But in any event, under Rule 60.02, it allows a party to challenge an order that's void. And as I just said, unless that order is void because there's no jurisdiction, then the order is just voidable. And this court has said, or I think this is the Court of Appeals actually that said that due process arguments like this would, if true, render a judgment voidable and not void. And so this doesn't fall in under Rule 60.02. And also with regard to the denial of the petition for exoneration, again, there's nothing that would render that judgment void either. So I think that's all that I have. If the court has any further questions for me, I'd be happy to address them, particularly with regard to the procedural issues. But as I understand, I don't.
General, why doesn't this fall, in your view, within the carve-out under 5904 for a new issue? Opposing counsel said it falls within the third category, do substantial justice. Why, in your view, does it not fall within that category?
I'm not actually sure, Your Honor. I would have to go back and look at my brief. Again, I was relying on case law that said that Rule 5904 just does not allow you to raise a new issue. I'm not sure how we get to something contrary within the rule itself when the case law is pretty clear that that's not possible.
Okay.
With that, I would simply ask this court to
General
affirm.
Lundy.
Thank you, Your Honor.
Mr. Mosley, I think you've got your rebuttal time if you'd like to use it.
Very briefly, Your Honor.
Yes.
And to respond to the question about the potential conflict in case law, I would say that as I read the quotations that were dealt with in the appellee's brief, the idea or the concept that came to me was that when you have a new theory of the law, and I'm not talking about in terms of new to this case, but a new theory of the law generally, such as if you're going to challenge the order of the court because the court didn't wear a green tie on St. Patrick's Day, then you can't raise that in a 59.04. That it's so novel that it's insane, and that's an extreme example.
What prevented this from being? I'm struggling to understand at the very least what prevented this from being raised in the petition, and so why? And let's assume for purpose of argument you're right as to the initial matter. Couldn't this have still been raised in the petition? And I mean, why is the first time it's being raised in the motion to alter or amend?
I'll speak to that, and if you'll pardon me for being blunt, because in essence you had an attorney who practices primarily in that court, who is familiar with the culture of that court and the procedures of that court. And as Judge Turner indicated in his hearing, they don't do final forfeit hearings down there, and so it never entered his mind. He doesn't practice bail bond laws as his primary focus.
But is that a justification for not raising something in the petition?
It is a reason. It is not a justification.
And is it a legally sufficient reason for not raising it in the petition?
Your Honor, again, I think that we're in an awkward place simply because if the court finds that this was an issue that was waived because it was not raised in the initial petition, then essentially what that does is that opens up the door for surety to file a 204 petition on this issue, because at that point in time there's no claim preclusion, there's no res judicata on this, because in essence what occurs is that the issue has not actually been appropriately raised. And one of the purposes of a Rule 59 motion is to prevent the kinds of repetitive appeals and addressing of the issues, but to simply resolve all the issues that are present. I think that's primarily the reason why, rather than file a new petition, it was more expeditious and quite frankly, more in line with the purpose of the
Aren't you
rules.
precluded from raising issues that you could have raised, not just issues that were raised? And isn't there a bar in terms of if I could have raised an issue but I didn't?
Well, Your Honor, we are in some very uncharted territory as far as Rule 204. It is an ancient rule. It's a rule that goes back, I believe, to 1858 and probably before then. But for most of its history, it fell under what was called the Franco Standard. And the Franco Standard, in essence, meant that in order to invoke 4011-204, you had to show such an extreme cause as to render it pretty much a useless relief. That the Supreme Court had said for years that Franco's controlled, and that required you to show that at the time that the final forfeit was entered, the defendant was dead or incapacitated in some fashion and could not appear. In 2019, the Supreme Court said, no, that Franco standard is no longer good. So we have a real dearth of case law, and essentially what we have is an attempt to carve out that case law. There could be an argument to be made that you have to make every claim possible under 204, but that's simply not the law as it exists right now.
All right, you can wind down and close, Mr. Mosley.
Thank you.
Thank you.
And I appreciate it, and I apologize again for being late.
Thank you for that. Matter will be taken under advisement, and we appreciate the parties' arguments and briefs. Madam Clerk, call the next.